the lawyers for Public Enterprises Minister Pravin Gordhan have lambasted Public Protector Busisiwe Mkhwebane for having disregarded the Constitution. Yesterday, the Pretoria High Court setting aside her report on the so-called Sars rogue unit. Now, the judges have ruled that Mkhwebane's investigation on the rogue unit fell outside the jurisdiction before her start at the office. Now, joining us to discuss this is Tebogo Malaji. He is Minister Pravin Gordhan's lawyer. Mr. Malaji, this question around the rogue unit, and you saw me using the rogue unit in inverted commas, it's something that has been a subject of public discourse, given the appearance of the minister at the State Capture Commission of Inquiry. Do you think with this judgment it can finally be put to bed, or is that something that you think you're still going to be preoccupied with for some time?
Well, we'd like to think that the judgment brings an end to reference to that unit as a rogue. Even the judges themselves criticized the public protector for having followed that narrative blindly and feeding into it. The unit has now finally, with the full bench of 3 judges, been determined and found to have been lawfully established. It's operated lawfully. And the judges were very unhappy with the fact that the public protector disregarded a body of evidence presented to her by Mr. Pillay and Mr. Van Lockerenbeck regarding the functioning of that unit.
Yeah.
It's collected revenue for you and I, clearly. And that's the one part that South Africans have forgotten about. It's an important investigative unit, which was targeting high-risk tax dodgers. It was a very important unit. So we hope it's an end to that narrative.
Before we get into the judgment itself, which was quite scathing on the public protector, there is something, though, about this unit, given that we're talking about the minister having appeared at the State Capture Commission of Inquiry, and that is that this unit, how could we sit here and say without flinching that the unit operated legally when Advocate Mbofu was saying at that commission, which is what the minister agreed to, that this unit ought to have existed and housed within the National Intelligence Agency. But as it was said at the commission, the NIA lost appetite to have this unit exist there, but it still existed anyway outside of the legislative framework. So can we still say, though, with certainty that this unit operated legally?
Well, that is the very essence of the judgment. I mean, the finding of the court is that what Advocate Sikhakhane found with his panel, that the operation of the unit was illegal, was certainly a wrong conclusion. And the courts have now pronounced that there was no contravention of the intelligence legislation, and there was certainly no contravention of Section 209 of the Constitution. In fact, I mean, the judges have gone as far as to say she's gotten wrong as a matter of law in thinking that Section 209 applies, and certainly there is no contravention of the intelligence legislation. What people forget is, in order to catch tax dodgers, you of course need to collate all of the information you require as a revenue service about the activities, illicit as they are. And all that unit was equipped to do was, it was a very well run unit with capacity to be able to trace those tax dodgers who are involved in typical illicit economic activities. The activities were absolutely 100% above board. In fact, if you look at the judgment, what the judges say is they go to town analyzing the evidence of Mr. Van Lockerenbeck and Mr. Pillay about the operations of that unit and its legality, and criticize heavily. You know, the word egregious comes from the fact that the public protector flatly ignored all of the evidence put before her about the operations lawfully of that unit. You know, so it must put to bed the debate.
The word dishonesty, or should I say the word dishonest, it came up in this judgment, and we know that it came up, I think, in 2 previous judgments on separate matters. What do you think that says about the public protector's legal acumen, if you like, or legal understanding? Because this is something also that has come up to say her understanding of the legalities whenever she compiles these reports, it would seem that it's in question.
Yeah. Look, for a court to pronounce that a litigant was dishonest in their affidavit is a serious finding. It doesn't have, you don't have to be a lawyer, an advocate for that matter, for that finding to be elevated to anything else. It is a very serious finding, and it is precisely that dishonesty which led the court to pronounce that she should personally be held liable for costs in this matter. And the dishonesty, as you would remember, relates to whether she had or did not have, and whether she had regard or did not have regard to the now reviewed and set aside Inspector General's report, the Inspector General of Intelligence. And that report was itself flawed, and a court has reviewed and set it aside. And the court was very unhappy with the fact that in her own report she says she didn't rely on it, but she then later on considered that she did in fact have regard to it. So it is a serious finding. And you'll remember that in the judgment, the courts have in fact referred its own judgment to the, they've directed the registrar of the High Court to submit that judgment to the Legal Practice Council so that they can consider appropriate action against the Public Protector.
Yeah. Before we talk about this 15% that she now is liable for, I just want to touch on what the response has been from the Public Protector's office, and the spokesperson being quoted as saying the Public Protector is studying this report on grounds on which the High Court set aside the evidence-based findings, and that the related appropriate remedial action with the view of exploring the options that are available to her. Does that sound to you like someone who is contemplating going back to court to challenge this outcome?
We would hope not. Look, our court system, as you know, allows a party aggrieved by a lower court's outcome to appeal. But I mean, these are public funds that are going to be applied to pursue this appeal. 110 pages have been devoted by 3 judges who unanimously, chapter and verse, go through all of the complaints that the minister had put before them and finds her guilty in very serious terms. And they've used very negative adjectives in describing her conduct and in describing her findings and report. One would hope that, having read this judgment, objectively speaking, even those that act for her would advise her not to pursue an appeal.
Mr. Malach,
it's a very scathing judgment and a very well-reasoned judgment.
Your comments now, I don't want you to speak about the person of the Public Protector, but you are a lawyer, she is a lawyer, and I think we were talking off air where you were saying she's actually senior than you in terms of the legal practice. What do you think, though, is the reason why she gets things so wrong?
Well,
does it have to do with the competence or understanding of the legal framework?
Clearly, I obviously can't comment on that. I mean, in terms of how her office functions and how her investigations are conducted. I can only comment on what the judges themselves have said. They've expressed themselves disappointingly on many aspects of her investigation of these matters relating to the minister. They've used words such as illogical, irrational, fallacious, egregious in describing many aspects of
this. Is an advocate we're speaking about.
Well, it is
not an attorney.
It is an advocate. She is trained as a lawyer, much as attorneys are, and we always say, if you hold an opinion as a lawyer and you intellectually, honestly hold that opinion, yes, it may be wrong. That is why there are always 2 parties in a case, and one of the parties will come out as a loser in that case. It's because a court would have pronounced on whether the one lawyer's opinion, or for that matter, the facts which the one party has put before the court are to be accepted or not. So that is a normal occurrence. What is not normal about the outcome in this case is 110 pages, and I mean, if I had the judgment before me, I would quote no less than 10 paragraphs in which the court has expressed itself in a very negative way around the conduct of the Public Protector. And her failure to apply herself to the facts and a failure to apply herself to the legal prescripts that are applicable to this matter.
She's personally liable to pay 15% of Minister Gordhan's fees, as well as Pillay's and George Mahashula's legal costs. How much is that?
Well, it's difficult. Yeah, well, it's difficult to say. All I can tell you is, I mean, we're talking about 3 legal teams, each of which had a senior counsel representing them, and a junior counsel accompanying them, plus attorneys. So it will be quite a sizable. It will be quite a sizable amount of money. That much I can tell you.
You're not willing to give us the rands and cents, are you?
Difficult to say. Very difficult to say.
All right. Tebogo Malaji, let's end it there. Thank you very much for making the time to come talk to us in studio here. Tebogo Malaji, he is the lawyer for Public Enterprises Minister Pravin Gordhan.